Pari passu. It is a Latin origin. It means ranking equally without preference, that is, with equal footing. The Latin term explains equal rights to equal parties. The application of this Latin phrase mainly found in context to the liquidation, bankruptcy, but also in case of inheritance. To understand this principle, we take the example. Say Mr. A, B and C has lent or financed money to a company called X. Now X company is in winding up process. The lenders, Mr. A, B and C, as to the very Latin principle, will get equal shares as they are in equal footing from the process of liquidation. To understand the pari passu charge, we have to take the help of illustration. There are 4 banks funding a project of a company. The banks are A, B, C and D and the company is X. A bank forwarded a loan of rupees 10 lakh, B bank 20 lakh, C bank 40 lakh, D bank 80 lakh. The banks had formed a consortium in the financing of the company X. Now the company X becomes bankrupt and goes to liquidation. On the banks, the charge is created. In the consortium, the bank will realize the loan at a ratio of 1:2:4:8. This is pari passu charge. Again, we take the another example to understand first charge and second charge. Bank A had given a loan to the company X on tools and machineries, and Bank B had given loan to company X on raw materials and stock. Now, X company goes to liquidation. When the tools and machineries were liquidated, to meet the loan, Bank A have the first right to realize the loan, that is first charge. When the raw materials and stocks were liquidated, Bank B have the first right as first charge. Now there are surplus fund after paying the Bank A, and Bank B's total loan has not been realized from the raw materials and stock. Now Bank B can claim over the surplus fund as second charge. On the remaining fund, after fulfilling the first charge, second charge can be made if the balance is due to the creditor. We also find the principle of pari passu in debentures. Say company X has raised fund in 2010 by issuing debentures. Again, the company X has raised fund in 2020 by issuing debentures. Now, in issuing the debentures in 2020, the term pari passu is mentioned. Generally, if pari passu not mentioned, then at the time of realization, the debentures of 2010 will be taken at the first instance than of 2020. But as the term pari passu is used in the debentures of 2020, then all the debentures of 2010 and 2020 have to be taken together, that is ranking equally without preference. Again, in the loan agreement, we find the pari passu clause. Why it is used in the loan agreement? Because when the question of realization of loan arises, the borrower will stand in the same footing with the previous borrowers. This clause acts as a security in the hand of the latter borrowers or creditors. Some of the landmark cases based on this very principle of pari passu are: 1. Employees Provident Fund Commissioner vs. Official Liquidator of SK Pharmaceutical Limited, Supreme Court 2011. 2. Jitendra Singh vs. Official Liquidators and Others, Supreme Court 2012. 3. International Coach Builders Limited vs. Karnataka State Financial Corporation, Supreme Court 2003. 4. Joseph vs. Official Liquidator, Kerala High Court 2001. 5. Punjab National Bank vs. Trinity Forge Private Limited and Others, Bombay High Court 2020. At last we may say, the application of the very principle of pari passu is that all unsecured creditors shall stand in equal footing in the process of liquidation and bankruptcy and share equally on the assets of the company or firm or in proportion of the debts during the sale of the assets.